The Supreme Court has done it again. Hi, I'm Dan Stein, and we're going to talk about the case today on DACA, Deferred Action for Childhood Arrivals. And once more, the Supreme Court has run against conventional wisdom and torpedoed the Trump administration's dreams of ending what we believe is a patently illegal program. Joining me to talk about this is Dale Wilcox, who's the Executive Director of the Immigration Reform Law Institute, and Matt O'Brien, who is FAIR's Director of Research. Welcome to you both.
Thank you.
Thanks for having me.
All right, so we all saw the decision that came out today, penned by Justice Roberts in Department of Homeland Security versus Regents of the University of California. This was an appeal from the Ninth Circuit Court of Appeals and part of the Trump administration effort to end a program that was begun in the Obama administration that said if you were brought here as a juvenile, that means one day under the age of 18, you could qualify for this program and remain indefinitely and get work documents and never have to worry about being deported. Okay, the first question, no problem, just pick it up where I leave off. DACA sounds like a great idea because after all, these people were brought here as children. So what was the problem with what President Obama did back in 2012?
He had no authorization under current statutes to do what he did. The Department of Homeland Security just can't go around handing out status to individuals. Congress has carefully crafted a body of statutory law that tells who the administration can give status to, who's lawfully present, and who can work in this country and obtain Social Security numbers, Medicare benefits, and whatnot. The Obama administration ignored the law. And in fact, Obama admitted before DACA was implemented, he didn't have authority. He was not king. He couldn't do this. But because the so-called DREAM Act, which would accomplish pretty much the same thing as what DACA did, has failed in Congress 20 plus times, Obama got tired of waiting. The pressure was too much from his constituents, and he implemented this illegal program.
So Matt, why has Congress laid out this carefully tailored statutory scheme in law that controls how many people may enter, who may get those green cards, and who may work in the United States?
Well, it's to preserve the integrity of our borders. I mean, basically, Congress's responsibility as the legislative body for the country is to define where the United States starts and stops, which is partially defined by our territory, but the territorial limits are reinforced by the immigration laws. And so it's up to Congress as the representatives of the people to determine who can come in and under what circumstances. And under the plenary power doctrine, which is a legal doctrine that affects how immigration laws are interpreted, those decisions belong to Congress first, and then whoever in the executive branch that Congress delegates them to. The rule should be that the judiciary should review as few of these cases as possible in as limited circumstances as possible.
So if Congress has set up a statutory scheme to protect American jobs, preserve the environment, protect the integrity of the American infrastructure, institutional systems, cultural systems, what does it mean if a chief executive simply ignores that and just starts handing out work documents?
Well, it's an unconstitutional usurpation of Congress's function. It's a separation of powers issue. Basically, President Obama appointed himself, the term Dale used was king, and I think that was accurate. He acted as the whole sovereign. We have a unique system of government where the sovereign is composed of three different parts, the legislative, the executive, and the judiciary, all with separate functions. Here, what Obama tried to do was exercise the executive and the legislative functions at the same time, which he cannot do under our constitutional system.
Well, Dale, did Obama think that he had the authority to do this during his first term when he was talking about it?
No, he didn't. He actually waited to the end of his first term and sought to, or actually, I'm sorry, yeah, he didn't do it in his first term, and that angered a lot of people, and he waited to the end of his second term, and in fact, the Supreme Court, the dissent here, noted that future administrations are going to be hamstrung now if this legal precedent that the court has laid down today, that previous administrations can institute illegal policies and the next administration cannot rescind that administrations from now on will be able to usurp the law.
Now, do we really believe that's going to be the case in a Democratic administration with a public policy that the left side of the aisle believes is unpopular?
Certainly, they're going to use this in future administrations.
All right. Anyway, but for the average American, all right.
Yeah.
Next, Obama himself said this is illegal. I don't have the authority, but I'm going to do it anyway. Try and stop me.
That's right.
Right? He gets sued. There are several prongs. He tried to do it for their parents too, and some others. It gets all the way up to the Ninth Circuit Court of Appeals, I guess, and they basically said it's wrong because even though Obama did something without any statutory authority, they can't undo it without some kind of elaborate procedures, right? I mean, that's what the lower court said, and then the Supreme Court kind of affirmed that.
Right. You're exactly right. And what the court didn't do today was the court did not say DACA is legal. The court didn't go there.
No court has said DACA is legal, right?
Exactly. In fact, it's only been the opposite, that we've had a ruling from the Southern District of Texas and the Fifth Circuit that a similar program, DAPA, which Obama tried to institute, was illegal. And they based that off of how DACA was being run. So in fact, what the court did today was it said that the procedure that President Trump used was unlawful. It was what's called arbitrary and capricious under the Administrative Procedure Act. He didn't follow the correct procedure to rescind it. The court was very clear in its opinion, and all parties admitted to this, that DACA can be rescinded. It just has to be rescinded the right way. Now, where the majority and the dissent parted ways, the majority said, okay, the administration didn't give an adequate explanation as to why it was rescinding, so therefore it was arbitrary and capricious. The dissent was saying, wait a minute, this is an unlawful program. They don't need to give any policy reasons to rescind it. They don't need to consider that DACA recipients might be relying on this, have some kind of reliance interest. It's illegal. So what you're ordering DHS is keep enforcing an illegal program. That's what the majority was saying today. Go back to the drawing board, give us adequate explanations why you want to rescind this, and then, we'll consider that later.
Well, so first of all, we have a memo that Obama issues that's illegal. And then we have a court saying in order to undo an illegal memo by a subsequent administration, they have to go through the elaborate rulemaking procedures of the Administrative Procedure Act, notice and comment, etc. And then, and we've seen this before from Justice Roberts, right, Matt, that he basically says, I'm looking at the rationale. He did this before in an immigration case. And, I'm siding with the liberal side because, I just think that even though we're getting a reason, I just kind of think this pretextual. So, you all need to go back and give me a better reason. And maybe by the time of the next election or the time it comes back to the court, you all will figure out how to resolve this because it's messy. Wouldn't you say that's what's going on?
It's exactly what's going on, and it's inappropriate. The courts are not supposed to do general balancing policy tests. That's Congress's function. What the court is supposed to be doing is applying the standard common law rules for looking at and interpreting legislation, determining did the executive apply this consistently with the will of Congress. And the answer in this particular circumstance is no, because as Dale pointed out, Congress never intended for the president to be able to expand the legislative categories of people who are considered admissible to the United States without Congress doing so. But there's another aspect to this that's even scarier. The court has overinterpreted the relief that was given. Even if we just accept DACA as a given, all it is deferred action. And what deferred action is an immigration plea bargain. I admit to the federal government that I'm here unlawfully, and the federal government exercises its discretion to not deport me. But that discretion is subject to virtually no limitations. The government can refrain from deporting me for a day for logistical reasons, or it can refrain from deporting me for several years, as was often the case when we had people who say were convicted of crimes in the US during communism and couldn't be deported to Cuba without diplomatic negotiations. So there's an overinterpretation. This is not really a form of relief. It's just the government saying we're going to temporarily halt deportation. And what's even more alarming about this decision is Dale mentioned reliance interests. So the court is talking about there are certain situations in law where if the government does something and you rely on that, then even if that thing wasn't legal, the government is stuck giving you that benefit.
Right.
However, there's oodles of precedent saying that only Congress can set immigration laws. And so estoppel, which is what this concept is called, that reliance on the promise has only limited application in immigration. So what I'm concerned about is every district court judge in the Ninth, the First, and the Second Circuit, which are very liberal and where most of these people live, now going to talk about reliance interests and issue injunctions barring the removal of anybody who was ever affected by the DACA program.
Well, even worse than that. I mean, let's suppose you have President Biden in 2021. We've got something like 15 million illegal aliens in the United States. What's he going to, and remember, it's not just forbearance from deportation. They're giving work authorization. State after state is now giving them benefits. I mean, UVA just decided they're going to give illegal aliens admission to UVA, and I assume financial aid and everything else. I mean, there's a slow and steady erosion of the distinction between citizenship and alien, as well as legally resident and non-legally resident or illegally resident aliens. And it's all getting wiped out. So if you're President Biden, and you see you have this precedent where you can literally add tens of millions of people to the labor force looking for jobs by giving out work authorization to people with no right to be in the country, what does this precedent mean?
Well, I think more importantly, from Biden's perspective, it means that you can add tens of millions of people to Democratic voting rolls. I mean, clearly this is something that Democrats have been doing for some time. You know, they're not admitting people from conservative countries. We don't have an overwhelming number of Estonians coming here and voting Republican. These tend to be from people that have leftist Marxist governments in their countries, and they tend to vote Democrat because they come here and they want benefits that they get, like free health care and welfare benefits and things of that nature. So this is alarming because it sets a precedent for Democrats to use this as the basis for handouts to people that are not even citizens to attract them here to the United States and encourage them to vote for Democrat policies.
Well, you know, they can't vote today, obviously, DACA. They can't vote today. But the long game here is keep them in the country until we get an amnesty that will put them on that path toward being able to vote.
So if I'm a Trump supporter, or at least a supporter of the plan to end DACA, there's an election in November. Obviously, things are unconventional, but what's the fastest way the administration could go about reissuing the basis for ending DACA and finding its way up to the Supreme Court? What's the plausible timetable if they started working tomorrow on an APA-compliant rulemaking process?
Yeah, we're possibly looking at years again, and that was the plan. Slow things down in court until the Trump 4 years expires, and then their hope is to get someone who has a different point of view on DACA. All is not lost here. We actually still have a case ongoing. This case, as I mentioned today, was not really about whether DACA was legal. It was about whether the way the Trump administration went about getting rid of it was legal. We have a case still down in Texas. It's Texas versus the United States, and it's in Judge Hanen's court, the Southern District of Texas. And this is the same court, the same judge who found DAPA and extended DACA unlawful. And of course, that's in the Fifth Circuit, which also upheld Judge Hanen's ruling. That case has been stayed. That case, which was brought by 7 states, has been stayed until the Supreme Court rules in this case. So that case is going to pick up again, and they are at the summary judgment stage. So hopefully Hanen will speed things along. We'll get a summary judgment ruling. It'll be appealed to the Fifth Circuit. we're
Yeah, but are the
probably
government's arguments in that case any stronger than they were in this Regents case? Because isn't the Supreme Court going to come down the same way and just say, oh, same arguments, same
no, no.
non-convincing basis and rationale?
No. There was a different basis there. Here, it's in the Regents case that was decided today, did the administration follow the requirements of the Administrative Procedure Act in rescinding this? Did they give reasonable justification for withdrawing? Okay, in Hayden's case, the states have directly challenged DACA to say this entire program is illegal. It doesn't have anything to do with Trump's rescission. It's a direct on attack of DACA. Is this program legal? And Hayden found with DAPA and extended DACA that no, it violated the Administrative Procedure Act requirement of notice and comment if you're going to have rulemaking. The Obama administration created DACA by a policy memorandum, but that was a rulemaking. So they must submit it to notice and comment. They did not do that. So number one. Number two, substantively, it violates the Administrative Procedure Act because it violates the INA.
So
Obama didn't have the authority to do this.
Say that. I mean, why, if Obama didn't comply with the APA when he issued the original memo, why can't that be a basis for simply saying the whole rule was originally illegal and that's the end of it? Why it sounds like these double standards. If you are a supporter of the Trump administration's approach, you can't help but see the diabolical heads I win, tails you lose approach here.
Oh, you're absolutely right, and that's what the dissent, Justice Thomas, Alito, and Gorsuch argued. They said, "Look, this thing was illegal from the beginning." And they didn't follow the APA in the beginning. So how can you require them? It's perverse. Then he actually used that language. It's perverse to require the Trump administration to follow the APA in rescinding an illegal rule that did not follow the APA in being implemented.
All right. So in closing, I want to know what each of you think is behind Justice Roberts' pattern, behind what he does in these kinds of cases, because we've seen it before.
Well, the dissent called him out, and I found this sentence particularly interesting. Today's decision must be recognized for what it is, an effort to avoid a politically controversial but legally correct decision. I just think Roberts didn't have the stomach for this. It was the right decision would have been to invalidate DACA, but I think he let his sympathies for the DACA recipients and their background and all these other, how much they contribute to the country and whatnot, all these amicus briefs that said, these are great people and we should not enforce the rule of law. He just let that guide his conscience. And I think we saw that in the census case. Roberts was the swing vote there.
You different view, Matt?
I think it was an emotional decision. And I think it's unfortunate because when you put on a black robe and take the bench, you have a responsibility to separate your personal opinions of how good or bad a policy is and apply the law. And there are a very established set of rules for limiting the gray areas that judges are looking at. So judges aren't a super legislature who are responsible for, putting on a black and white shirt, acting like a baseball or football umpire and saying, oh yeah, this was a good decision. What they're supposed to do is say, did Congress have the authority to do this? And did this comply with the Constitution? And this particular case was a personal judgment about the validity of the decision-making and the consequences, not about how the law should specifically apply in this instance. And that's unfortunate.
Yeah, I'll give you my theory about it. And I think we've seen this with the Obamacare decision and several immigration cases. And my impression is that the Chief Justice has been spooked by the blowback from Citizens United, that he has been spooked by the threats of the Democrats to expand the size of the court, and that he has decided as an institutional figure, as the Chief Justice, Justice Roberts believes that he has to prove that the court is above partisanship, that if he always sides with the conservative majority, in these 5-4 decisions, it will undermine public confidence that the Supreme Court is not a partisan institution. And so he's gotten it in his head, even though if it were a liberal justice who were the Chief Justice, this would not be the case, that he can bob and weave back and forth across the aisle or find an emissary like Gorsuch in a recent case to do this for him so that the public can, so he doesn't get the left wing just routinely mad at him and running around, basically burning down buildings. And so, he seems like he's been played, that he can be played and manipulated with public opinion and pushed around to blatantly, in this case, we're talking blatant, brazen illegality, clear on its face, no dispute about the legality of this program, and still comes up with another one of these things where he's like, well, we have to be convinced that the rationale was legitimate. He didn't just say, oh, you didn't comply with the strict notice and comment rules. He starts commenting on the weight of the arguments and whether he finds them convincing and whether they have to consider the hardship of these young people and blah, 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 blah. There's simply no institutional basis for reviewing those factors based on the legal analysis that was presented in front of them. And there's the conservative court, and Thomas, the dissent, you ought to read. Everybody should read this dissent. It's as clear as anything Scalia might have written, that this is flawed judicial reasoning to reach a predetermined outcome. They're kicking the can down the road. And the biggest tragedy of all this is that if they had decided the proper way, it would have thrown the obligation back to the Democrats to actually come forward and begin negotiating honestly with Republicans. If you want to really give some relief to these DACA folks, you do it legislatively, and you have to be grown-ups in the room and trade off things like E-Verify and some other things that have been asked for decades. The Democrats have been playing this game since 2003, Dick Durbin and others, where they manipulate the so-called DREAM Act kids. If they really wanted to see this relief passed, they could have passed it years ago. First 2 years of Obama's administration, for example. Instead, they continue to use it as a political bludgeon, and now Trump is going to have to deal with this through the election. And then let's assume Trump gets reelected. Where do we go from here? Trump going to start negotiating again with the Democrats? Why do they want to negotiate with him when they can continue to use this thing as some kind of bludgeon? And it leaves us exactly where we are. So the Supreme Court isn't doing anybody any favors by playing this very unpredictable and highly politicized role. Any closing thoughts, gentlemen?
I've heard that theory also, and I think that probably does play a part into what Roberts is thinking. The integrity of the court, he wants to appear as unbiased, also wants to protect the court makeup, as you stated, 9 members. There has been talk, because decisions weren't going the Democrats' way, that they were going to attempt to increase the number of justices.
And abolish electoral college and everything else, but the point is the Chief Justice shouldn't respond to that kind of threat, at least.
I absolutely agree. I agree. He is the new Kennedy. He is the new swing vote. I guess those who do support Trump maybe have something to look forward to in the next 4 years. If he gets to appoint another justice, then Roberts won't have that type of power any longer.
No.
I think there's a more ominous current running behind all of this. And the fact is, if you look at this, people who are unlawfully present in the United States have virtually no legally protected interest in remaining here. And yet we are wasting thousands of hours and thousands of dollars of taxpayer money repeatedly litigating about what people who have violated our immigration laws, what kind of lawfully protected interests they have to stay here. And so the thing undergirding this whole thing is that by actually ruling on this the way it did, the court has implied that these people have some kind of a protected interest in remaining here. And that sets up a precedent for all kinds of other terrible decisions to come in the future.
Well, for all Americans who care about the rule of law and the ability of this country to manage immigration rules, manage our borders, to restrain an unbridled executive in the future who wants to ignore immigration limits and the protections implied by our immigration-related statutory scheme, as well as the primacy of Congress in being the sole legislative authority in determining these factors. These are ominous storm clouds indeed, and we will have to keep monitoring these developments. And hopefully the Trump administration will go back to work and clearly articulate why this decision was wrong and why they need to continue to fight this battle. Dale Wilcox, Matt O'Brien, I'm Dan Stein. Thanks for joining me, and we'll be back again to talk to you soon.